Good evening. Welcome to Kent County Board of Adjustment, March 20th, 2025, public hearing. Can you please, roll call, please, make sure we have a quorum.
Yes, sir. Mr. Gallo?
Here.
Mr. Carter?
Here.
Mr. Jenkins?
Here.
Ms. Hudson?
Here.
Mr. Cusick?
Here.
That's 5 present.
Thank you. Introduction of staff, please.
Good evening, everyone. My name is Jamie Fensky. I'm the hearing officer for tonight's Board of Adjustment meeting. To my right is Jesse Lindenberg, another one of our planners. To my left is Mark Kennedy, our IT staff. And to the far right is Fred Townsend, our legal counsel for the evening.
Thank you. At this time, everyone please stand for the Pledge of Allegiance. Any additions or alterations to tonight's agenda?
Yes, sir. So we are removing application A-25-07 for Matthew Bowler and Sharon Agee. That is removed and is not being heard tonight.
Thank
Mr.
you.
Cusick, there's a second change to the agenda. The parties, the appellant and the county, have agreed to delay consideration of appeal hearing A25-10, ANG Automotive. So what I'd like to ask you to do is accept a motion to table that matter, and it will remain tabled until a later date, at which time we may hear it.
Okay, when would you like to do that motion? When that time comes?
We could do that motion now. We could do that motion now in conjunction with adopting the agenda.
I'll make a motion that we table the appeal for now.
Second. Got motion and table, motion and second to table application A25-10. All in favor, say aye.
Aye.
Thank you.
Thank you. We'll have public hearing introduction.
Okay, so good evening, ladies and gentlemen. My name is Jamie Fensky, and I'll preside as the hearing officer for tonight's public hearing. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on these applications before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. If there is a group of interested citizens in favor or opposed to any of the applications, they may wish to elect one spokesperson among them to present testimony to the board. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there should be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to the other participants in this hearing, a maximum of 5 minutes will be allotted to any person who wishes to provide testimony. The chairperson of the board has the discretion to allow additional time if deemed to be necessary. To make statements when your application is called and for the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each variance application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by the staff. The board will then receive testimony from all of those in favor of the application, followed by testimony of those who may be opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call the Kent County Planning Department tomorrow between 8 a.m. and 5 p.m. at 744-2471. All applicants will receive written notification of the board's decision. This notice may not be mailed until after the next scheduled meeting, but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearing was published in the March 2nd, 2025 in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications. Thank you.
Thank you, Jamie. At this time, we'll have a statement by council. Mr. Townsend?
Thank you, Mr. Cusick. The remaining items on our agenda are variance applications, and the test for granting area variances is set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty. The legal standard for area variances considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership, and to determine whether they exist, the board must consider the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And fourth, whether failure to remove the restrictions would create exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is met only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. The inability to improve one's business may qualify as an exceptional practical difficulty. And also, this is the consideration this is the point where the board considers whether the applicant is seeking more relief than is minimally necessary to relieve the asserted difficulty. In general, the board's not permitted to consider factors other than those listed. Therefore, those speaking both in support of and in opposition to applications are urged to present only information bearing directly on 1, the nature of the zoning district, 2, the characteristics of the area, 3, whether the requested variances would seriously affect neighboring properties, and 4th, whether applicants are confronted with challenges that rise to the level of exceptional practical difficulties. In general, presenters are instructed to exclude from the presentations any discussion of personal disputes or acrimony between the applicant and neighboring property owners, as the board is not authorized to resolve those disputes. Mr. Cusick.
Thank you, Mr. Townsend. At this time, we'll begin the public hearing.
Okay. So first we have application A-25-05 for the variance for A&G Automotive LLC. They are seeking a variance from the requirement that all buildings be located a minimum of 50 feet from a residential district or residential property line to allow motor vehicle sales, service, storage, rental, and repair use. The present use is vacant. Proposed use is motor vehicle sales, service, storage, rental, and repair use. It's in the Levy Court District 3rd for Mr. Angel. Located on the west side of North DuPont Highway, approximately 257 feet north of Main Street and Fast Landing Road, east of Cheswold. Here you will see the required 50-foot setback from any residential parcel. The existing building is approximately 4.3 feet from that residential property line. Staff's recommendation is to approve with the condition that they plant a screening buffer along the property line where the building is not. So you will see there the recommended screening buffer. This is looking north up 13, south towards the intersection. This is looking at the existing building. The existing building and the fence that's approximately at the property line. This is towards the front of the building, towards Route 13, and the aerial. Mr. Pardee, would you like to come forward? Thank you.
Good evening, Mr. Chairman and members of the board. Respectfully, John Pardee with the law firm Brockstedt Mendelis Federico here in Dover, and I represent the applicant, A&G Automotive LLC. Principal of my client, Richard Lafferty, is here tonight if there are any questions for the applicant. Jamie handed out to you a hard copy of our PowerPoint presentation, and I would ask if the staff could pull that up on the monitors. I will tell you that when I prepared this presentation, we had not anticipated that the appeal would be stayed, so I'm going to ask you to disregard those portions of my PowerPoint which speak to the appeal. I'll have to walk through it and sort of excerpt those out for you. So the first picture that you see up on the screen and also in the hard copies that I provided to you is a photograph of the property looking north. The next slide is another view. If you could go to the next slide, please. And you'll see that the property is zoned BG. The next slide shows the front. And by the way, I'll tell you that my client has been making extensive renovations of the building that was there, and the property as well has been cleaned up and cleared up very nicely, and they intend to have a first-class operation there, and I think they've demonstrated that with their cleanup of the site so far. Next slide just shows the side from the north looking south, and then the next slide is a survey. You can skip the next page and stay right there for just a second. This is the applicable code section, which is section 20571J of the Kent County Code, and I won't bore you with all of the details for purposes of tonight's hearing. The important provision is subparagraph 3, which essentially says that this proposed use can be made. It's a permitted use of the property if you can meet all of these conditions. And my client can meet all of the conditions except number 3, which is the minimum distance of any building from a residential district or residential property line shall be 50 feet. So if you can go to the next slide. As I mentioned, we can comply with all the requirements except subparagraph 3. If you go to the next slide, this is a really important point. This is kind of the reason why we're here. The building that is currently on the property has been there since 1950. And we know that for a couple of reasons. Number one, my client had a phase 1 environmental site assessment report done last year, and you'll see in a moment an excerpt from that report that is based on a conversation that the environmental company had with Superior Court Judge Jeffrey Clark, whose family owned this property and operated several businesses on this property for decades. And so the excerpts that you'll see from the report give the history of the building and the uses of the property. And I actually called Judge Clark and confirmed that history with him and walked through it. He offered to testify if we needed him to. I told him I didn't think that was necessary. But if you can go to the next page, you'll see this is the excerpt from the report, and it's a little small print, so I'll just read it to you. But it says that the present commercial building was reportedly constructed in the early 1950s for use as a granary, which reportedly operated as such until the 1960s. The present commercial building was later utilized as an antique store in the 1970s, and later a greenhouse garden center in the mid-1980s to the later 1990s. The building has reportedly been vacant since that time, and the property reportedly occasionally was utilized for limited used car sales. If you go to the next page, this is an excerpt from the Kent County Tax Mapping Office's website, and you'll see that it shows that the building that's currently on the property, which is a concrete block building, was built in 1950. You can skip the next page, and you can skip the next page as well. And let's talk about this. I don't know why it's showing up funny on the screen, but in the hard copy that you have in front of you, hopefully it looks a little prettier than that. But what we were suggesting is that in the event that our appeal was not decided favorably, then we would respectfully submit that the applicant satisfies the legal test for an area variance, which your counsel described to you. So next slide. Again, we can comply with all of the requirements except subparagraph 3, but that is not due to any fault of the applicant. Again, this is not something that the applicant did. This building's been there since 1950, and that creates this exceptional practical difficulty, which I'd like to explain a little bit about that. So next slide. We already discussed the history of the fact that the building's been there since 1950. So next slide. And we discussed this as well. We know that the property's been operated for a number of business enterprises over the years. Interestingly enough, talking about the car sales on the property, some of you who may be familiar with the area will remember that. But in January of 2008, the county actually issued a certificate of use for the property, which allowed the building to be utilized for automobile sales, notwithstanding that the building was less than 50 feet from the rear lot line. If you go to the next page, this is the actual certificate of use that was issued in 2008. Next slide. Mr. Townsend mentioned the exceptional practical difficulty test that was laid down by the Delaware Supreme Court in the Quick Check case in 1978. And we would respectfully submit that the test is satisfied here, because the harm to the applicant, if the variance is denied, would be much greater than any probable effect on neighboring properties if the variance is granted. Next slide, please. So let's talk a little bit about the harm to the applicant. If you were to deny the requested variance and insist on enforcement of the 50-foot setback requirement that is in Section 71J3 of Chapter 205, that would cause the applicant to endure a number of exceptional practical difficulties. The applicant would have to either move the building forward 40-some feet, which is impossible because you'd run in, the building be out on the highway at that point. The other alternative might be to chop off 47 feet of the rear of the building, which would not only be cost prohibitive, but it would render the remainder of the building substantially less useful. And then the third option would be to simply forego a use of the property which is allowed in this zoning district and has previously been permitted. But none of those options we submit would be reasonable under the circumstances here encountered, and they would cause the applicant exceptional practical difficulties because the property has been utilized for a variety of commercial enterprises, including automobile sales, for the last 75 years. If you go to the next slide, we talk about, by comparison, the relative harm to adjacent properties if the variance were to be granted, and we respectfully submit that that would be virtually zero. And that's because nothing new would happen from the perspective of the residential properties that are behind this property. You have to keep in mind that this building has been there since 1950, long before, not only before the county had a zoning ordinance, but long before any of those homes were ever constructed. So these homes were all constructed after the building was there and after all of these other commercial uses of the property were already being made. So because no adjacent residential property will experience any impact that would be new or different from anything that's already been experienced there over the past 75 years, we submit respectfully that granting the requested variance would have no meaningful effect on any adjacent residential property. Now, I'll talk for a minute, just briefly, about the other aspects of the Quick Check test, and I won't bore you with a reading of my February 3rd, 2025 letter, but I would note that that's part of the record. I think it was actually in the packet that you received. But I wrote a letter to the board explaining how we satisfy the Quick Check test. And I think it's important to note that the nature of the zone here supports a granting of the request. Like its immediate neighbors, To the south and the east, the property is Zone BG. It's located on a heavily traveled arterial highway, Route 13, at a signalized intersection, and the property has been utilized for commercial businesses as long as anyone can remember. Again, the building has been there since 1950. All of the neighboring properties in the area have coexisted with that building and its many different commercial uses over the past 75 years, and therefore allowing the building to be utilized for a commercial business that is similar in nature and scope to commercial business uses that have previously been made of the very same building. It would have no serious adverse effect on any neighboring property or use. So to summarize, we respectfully submit, if you can go to the last slide, just focus on the second paragraph there, that we satisfy the legal test for an area variance. Again, the harm to the applicant if the variance is denied would be much greater than any probable effect on neighboring properties if the variance is granted, and therefore we respectfully request your favorable consideration. I would note, importantly, that the staff recommendation report also recommends approval for all the reasons that I mentioned. So I'm happy to answer any questions you may have, and I thank you for your patience.
Thank you. Go ahead.
I think somebody's going to ask this, so I'll just get it out of the way. That recommendation was for conditional approval. Can you or your client speak to your position on the conditions that were described in the
Sure,
staff
and
report?
my apologies that I didn't address that in my presentation. I did have a chance to review the staff report this afternoon and noticed that it recommended landscape screening along the rear of the property, except for just behind the building. And I think the reason for that is there's so little space between the building and the fence that is there that I doubt that any trees you might plant there would survive. But my client is certainly, he had planned to put landscape buffering there. Talk to the neighbors, and he wants to be a good neighbor. So he was planning to put landscape screening there anyway, and we certainly consent to that condition.
Thank you. Any other questions from the board? Yep.
How long has Mr. Lafferty owned the property?
A&G Automotive purchased the property in September of 2024.
And did A&G install the roof on the property?
Yes.
So they made that improvement?
Yes. In fact, the planning staff, or I guess I should say inspections office, has been out there reviewing, approving all of the work that's been happening along the way. So they've significantly refurbished the building, put a new roof on it, and all of that has been reviewed and approved by the inspections department.
That executive summary that was submitted said that the building had been vacant since the late 1990s, and the property was occasionally utilized for limited used car sales. Individual sellers paid a fee to park, sell their vehicles at the property. Is the intention of A&G to do more than just sell cars? Will there be servicing of vehicles there as well?
I tell you what, those are questions that are probably most accurately answered by my client. So if you don't mind, I'll ask Mr. Richard Lafferty to come forward, be sworn, and he can address those questions.
Thank you.
Mr. Lafferty.
Just name and address for the record, Mr. Lafferty.
My name is Richard Lafferty. I reside at 316 Androsen Place in Townsend, Delaware.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Good evening, Mr. Lafferty. Yeah, could you just explain what your intention is with the property? How are you going to use? Is it going to be more than just sales of cars?
We absolutely plan on selling cars, and then the expectation is that anything that is sold there will be serviced if there's issues, any work that needs to be done prior to it being sold, or if a client has issues with it, we expect to be able to resolve those issues.
Would this location be an extension of other locations you have in the state?
No. No.
Thank you.
Yes, sir. Thank you all.
Yeah, I'm sorry. Please stand for some more
Oh, I'm sorry.
But while I'm thinking of it, you heard Mr. Pardee make a number of factual representations during the course of his presentation. Could you just say on the record whether or not those were accurate?
I did not hear anything that wasn't inaccurate. We had discussed all the prior, so yes, I believe it was all accurate.
Okay, thank you.
Mr. Lafferty, when you purchased the building in September of '24, were you aware that it had not had any uses that involved sale or repair of vehicles for many years? Were you aware of that?
Prior to purchasing it, we had looked into the use of the property, its zoning, and identified that in 2000, I think it was 8, it had been approved for car sale at the property. And we have met with the Levy Court Planning Department to confirm that. So we were aware it hadn't been used recently, but it had been approved. It's as far as we understood, and obviously it had been abandoned. There wasn't a lot of information available. But the information we had is its most recent use was car sale, so we assumed that doing that again would be an approved use.
So the reason I'm asking, and again, I'm sure that Mr. Pardee would prefer to address it, but just so that you understand, the reason I'm asking is because it had not been used for the sale of cars or repair of cars now since 2008, as far as we can tell, especially by the information was provided. And so, that use is somewhat expired after a year of not happening. So and that's why I'm asking the question, just so as you understand.
Ms. Denny, thank you for the question. We would acknowledge that the prior use had expired and been abandoned. I don't think there's any question about that. I think Mr. Lafferty was under the impression that since it had been used for that purpose in the past, it would be a use that could be made in the future as well. And it wasn't until after he purchased the property that he found out that there was this issue about the building.
Thank you. I just kind of wanted the record.
Sure.
Any other questions? Nope. I think we're good. Thank you.
Thank you very much.
Thank you very much.
If I may, Max Walton, I'm the attorney for the Department of Planning. As you heard with the landscape buffer, the department has no objection to the variance. If the variance is granted, the appeal that was tabled will go away.
Thank you.
Is there anyone else that would like to speak in favor of this application? Please state your name and address and allow our attorney to swear you in.
Sure. Good evening. My name is Michael Costello. My address is 3083 Kitts Hummock Road, Dover, Delaware.
Mr. Costello, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes. I represent the public, and I drive past this property quite frequently. And I think this is a great use for this property, and I'm glad to see that someone's taken the time, the effort, and the money to fix it up, clean it up, and now going to put it to good use. And that's my testimony, and I always appreciate coming down here and talking to you guys and ladies.
Very good. Any questions, comments? Nope. Good. Appreciate it.
Thank you.
Is there anyone else that would like to speak in favor of this application?
If there's anyone joining us online that would like to speak in favor of this application, please indicate by raising your electronic hand. No hands raised online.
Thank you. Is there anyone that would like to speak in opposition of this application? Oh, I'm sorry, sir. Did you want to speak in favor? Okay. If you want to come forward, state your name and address, and allow our attorney to swear you in.
Tom Antonio, 5 32 Main Street, Little Creek, Delaware.
Mr. Antonio, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. What is directly south of this property? Anybody know? What is it?
There's a vacant lot.
Isn't it Ben Dover Pornography Store?
I think there's a vacant lot.
So, Mr. Antonio, this is your opportunity to provide testimony.
Yeah, so I know that the direction is protecting a residential area. I can't think of a more American business than selling used cars. So somebody, either in King County or in the city of Dover, allowed a porno store 2 doors down. So I think the gentleman should have more than a right to run his used car sales there. That's my testimony.
Thank you.
Okay, is there anyone that would like to speak in opposition of this application? I'm sorry, ma'am, were you coming forward to speak in favor? Okay, if you can state your name and address and allow our attorney to swear you in.
I'm Angela Benson Jenkins, and I live at 33 Truman Court. That's my White House right there.
Ma'am?
Yes.
Do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, please proceed.
Yes, that's my White House right there, and we do not oppose. All I want to know is if there's any risk, because I have a home daycare. That's all. And, you know, we, like my husband told him, we want to be friendly neighbors. He spoke to my husband on a few different occasions. I just want to know if there's any risk.
So which of the white homes are you referring to as yours?
That one right there, that's mine.
Oh, I see, with a red arrow now?
Mhm.
Okay.
Are you talking about risk in relation to you having your home, you being allowed to have your home daycare there?
Oh, I'm pretty sure I can because it's been there for 14 years. I'm just wondering, like, cancer or anything like that. That's all. I don't want to oppose.
I'm afraid we don't have anybody here who could.
Okay, that's all I want to know. And like I said, I don't oppose. The building is beautiful because it was a terrible site. It's beautiful.
I can say that the applicant is not seeking any relief from any restrictions on the operation of the property that might relate to health. It's just this matter is a zoning code matter and not a public health matter. So whatever laws would apply to protect the public would be fully enforced if that business were to proceed.
Okay, because you said 50 feet, and it's not 50 feet. I'm just making sure.
So the zoning code, the public policy behind that zoning code provision relates more to the degree to which that structure it has a visual impact or creates a noise nuisance to its neighbors. The zoning code is not attempting to enforce restrictions that are designed to protect public health from contagions or from toxic substances. There are other bodies of law and governmental entities which are engaged in that activity.
All right. Thank you.
Thank you for your testimony.
Okay, is there anyone else that would like to speak in favor of this application?
Is there anyone joining us online that would like to speak in opposition to this application? Still no hands raised online.
Thank you. Is there anyone in the room that would like to speak in opposition of this application? Seeing no one, we will close the public hearing for application A-25-05.
Our next application is A25-09 for Fei Zi Wing, seeking a variance from the requirement that a fence may not exceed 4 feet in height in the front setback, and from the requirement that accessory structures shall not be located in the front yard or front setback to construct a 6-foot fence and legalize the existing accessory structures. The property is located on the southwest corner of Walnut Shade Road and Millchop Lane on the north side of Woodville Drive, east of Woodside. Levy Court District is the 5th. Zoning District is RMH. This is a survey of the property submitted for the application showing the house, the accessory structures, and the proposed fence in blue. The proposed fence is along the property line to the north there, along Walnut Shade Road, and then kind of curves around the side there of Millchop Lane. The existing accessory structures, there is an 8x15 structure that is going to be 7 feet from the property line. This property is having part of their frontage being acquired by DelDOT. That's part of the reason that they're here for the variance. So that structure will be 7 feet from that property line once DelDOT acquires that frontage. The other 2 structures on the other side of the house, the one with the arrow on it is 10x15. It is 10 feet from the front property line. The other is a small 4x5 well structure, and that is 2 feet from the property line. This is at the corner looking along Walnut Shade Road, the other direction of Walnut Shade Road. This is looking at the property kind of from that corner of Walnut Shade. This is looking along to Millchop Lane, looking from kind of the corner of Millchop Lane back towards Walnut Shade, and then along the other roadway there, showing the 2 accessory structures, and then up towards the house. Aerial, and further out. There's someone here to represent the application. Please come forward, state your name and address, and allow our attorney to swear you in.
Good evening, members of the board. My name is Frank Regan. I'm a right-of-way agent for the Delaware Department of Transportation. My address is 800 South Bay Road in Dover.
Mr. Regan, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. As Jesse mentioned, I'm assisting the property owner. I was involved in the acquisition of property for a transportation project that DelDOT's proposing on Walnut Shade Road between Route 13 and Peachtree Run Road. We acquired property. We've acquired most of the property for the project, including Mrs. Wing's property. And she's here this evening, as was noted, not because she wants to be, but because we created a situation for her with respect to removing fence and shrubbing, and she's proposing a new fence, as well as the issue with the existing accessory structures. It's a unique parcel, as you saw in the photographs. It's on a corner. It has 3 frontages on Walnut Shade Road, on Millchop Lane, and on Woodville Drive. So it's got 3 front yards. From a practical standpoint, Mrs. Wing uses the Woodville Drive frontage as her front yard. The rear yard backs up to Walnut Shade Road, and then the side yard is Millchop Lane. To accomplish the DelDOT project, we acquired approximately 4,000 square feet of her property along Walnut Shade Road and Millchop Lane. The lot was 16,000 square feet. We acquired 4,000 square feet, so we reduced it about 25%. We reduced the front yard setback along Walnut Shade Road by 7 feet, and it varies on Millchop Lane from 9 feet to 50 feet, particularly at that corner. That acquisition included improvements, primarily landscaping and trees and a fence along Walnut Shade Road that provides a substantial buffer to Mrs. Wing's rear yard. That is all going to be cleared and removed as part of the project, including a small wire fence that she currently has. So she's proposing the installation of a black aluminum fence, not solid, it's see-through. We included a photograph of the fence in the application. I do want to point something out, and this was an error on my part and some confusion Mrs. Wing and I had. The 6-foot fence is only going to be from the,
Sir, if I may, you can point right on that screen.
Awesome. Thank you. The 6-foot fence is only going to be from this point to this shed. The remainder of the fence is going to be 4 feet. And I apologize, I didn't point that out in the application, but I think it's an important point to get on the record, and we can have Mrs. Wing confirm that if it's necessary. I did want to just touch upon a few, I did want to address a couple of the recommendations by the board as it relates to the fence. I think some of it is eliminated, at least in our opinion, with respect to the fence now only being 4 feet for that section as it approaches Mill Chop Lane and then turns, on Walnut Shade Road and then turns onto Mill Chop Lane. As part of the improvement project, the intersection of Mill Chop and Walnut Shade is going to become an all-way stop. So the concerns expressed by staff, planning staff, was visibility at the intersection. So I think right now it's only a stop on Mill Chop Lane to make a right or left onto Walnut Shade, but it's going to be an all-way stop. And the stop bars are going to be fairly close to the intersection. So I think concerns with visibility will be eliminated as a result of that. In addition, as I pointed out earlier, the entire frontage along Walnut Shade is going to, all of the existing vegetation is going to be removed. And it's going to be what we call a clear zone, so that it will remain free of any trees or other impediments. So I think that will also be a positive with respect to visibility at the intersection. Lastly, currently, Mrs. Wing's property is about 2 to 3 feet below the elevation of the road, and that's not going to change. So obviously the road is higher. If there was a 6-foot fence, I think that would help. With the 4-foot fence, I think it's even improves the condition. In addition, while the setback, and this applies to both, I think the existing shed as well as the visibility issue, while we acquired 7 feet or reduced her frontage 7 feet along Walnut Shade Road, there's actually going to, from the edge of pavement when the project is completed to her new property line is going to be 25 feet. So that's going to be 25 feet that's open with no vegetation, no impediments. It's actually, the reason we purchased it was part of the project is to improve drainage along the road. So that's going to be a drainage ditch. So I think for those reasons, we believe the board can grant the variance that's necessary for the 6-foot fence in the front yard setback. Obviously, the accessory structures or existing structures, the two in front, from what I've been told by Mrs. Wing, have been there since the 80s at least. The 60s, okay. And the shed, while it is close to the property line, it's actually a temporary structure that could be relocated if it had to be. Obviously, it's been there for a while. But we don't think that granting the variances for the accessory structure as well as for the 6-foot fence height in that smaller area, is going to create any hardships or have any negative impact on the adjoining property owners. Because quite frankly, where she is on the corner, other than residential dwellings across the street, the only one is to the right here. That's the only one with a dwelling. Over here is a vacant lot. Over here is a vacant lot, which I understand has been approved, the subdivision has been approved for 2 dwellings. But again, I think the fence will not in any way negatively impact those neighboring properties. So I don't have anything further. I appreciate your time. And Mrs. Wing is here if anyone has any questions for her.
Very good, thank you. Any questions?
So the fence that's pictured here is the fence you're installing?
Correct.
So there'll be some visibility for the whole length of the fence.
Visibility through the fence.
Visibility, yeah.
Oh, absolutely,
I mean, you'll be able to
yes.
see through the fence.
Correct.
So typically, obviously, we're a little bit cautious when we make decisions about fences because of blocking the view of traffic and people, pedestrians and car traffic, but you can see through this fence. Okay,
Correct.
I just want to get that.
No, I
in there.
appreciate that, and you're absolutely right. And I do, one point that I failed to make, and with respect to the fence, obviously I noted that there's currently significant buffering, which provides privacy to her backyard. She's going to lose that. But more importantly, it provides safety for her and her dog. So that's why she's installing a fence, and she's installing the type of fence she is. And I think it will not substantially impact visibility because it's not a solid fence.
So essentially, the height is to hinder climbers.
Correct.
But it certainly will be visible so that there's really not going to be an issue with visibility, again, for pedestrians, traffic, somebody pushing a stroller. You'll be able to see what's coming and going.
Yes, we believe that's the
Thank you.
case.
What's the reason for the transition? What's the reason for the transition from the 6 foot to the 4 foot at that area?
I'll let Mrs. Wing give
Yep.
you 3 hands. When you raise your right hand, give me your name and address.
Mrs. Wing, so you would introduce yourself, give us an address, please, for the record.
Fay Wing, 14 Woodville Drive, Magnolia.
Ms. Wing, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
And you heard a number of factual representations made by Mr. Regan on your behalf. Were those true and accurate?
Yes.
My question was just the reason for the transition from the 4 foot to the 6 foot at that point.
For security, for my dog. I have a Husky Shepherd, so I want to make sure. And, what am I trying
Just
to
a
think of?
personal preference, really. I mean,
Yeah, that too, and it's my backyard, so, like he said, I'm losing all my privacy. So and I'm, as you can tell, I'm kind of tall too, so,
Yeah,
It's
I
mainly for
understand. I'm just curious, like why the transition was there, not the.
For my dog and security, people like to walk by and throw stuff at my dog. He's had bottles thrown at him, cigarettes, you name it, rocks. So, and then that way they can't come over.
All right, very good. Any other questions? Seeing none. Very good, thank you.
thank you very much.
Is there anyone that would like to speak in favor of this application? Is there anyone on the phone?
If there's anyone joining us online that would like to speak in favor of this application, please indicate by raising your electronic hand. No hands raised online.
Thank you. Is there anyone that would like to speak in opposition of this application?
Similarly, if you're online and would like to speak in opposition to this application, please indicate by raising your electronic hand. Still no hands raised online.
Thank you. Seeing no one, we will close the public hearing for application A-25-09. Okay, moving forward, we have application A-25-11 for Orchard Home LLC. Is there someone present for that? Thank you. They are seeking a variance from the requirement that the primary unit shall remain owner occupied unless the property is 5 acres or more to apply for a short-term rental. The present use is residential, proposed use is same with a short-term rental. Levy Court District is 3rd for Mr. Angel, located on the southwest corner of Pickering Beach Road and South Sandpiper Drive, east of Dover. You will see here that the applicant's property is approximately 0.14 of an acre. The required acreage is 5 acres, or the property owner must reside in the home when they are doing the short-term rental. This is looking at the corner of the kind of cul-de-sac that's there, if you will. The corner of Pickering. To the left is the subject property, and that's heading back into Dover. This is the subject property. That camper has been removed. Again, at the subject property, located at the corner. And the aerial. So if someone would like to come forward, state your name and address, and allow our attorney to swear you in.
Hi, my name is Vasily Ivanov, and I reside at 200 Bridge Street in Suffield, Connecticut, 06078.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
You may want to raise that microphone a little bit.
Thank you. Everybody had a lawyer. I don't have a lawyer, so I feel like a little David in a room full of Goliath. But I hope that doesn't affect my outcome here. I respectfully request variance for the residential use of short-term rental for my beach property located at 12 Sandpiper Drive in Dover, Delaware, 19901. This is a beach property with limited size of land available to the shoreline. And that makes the acreage compliance for zoning with 5 acres unfeasible. Granting this variance would allow me to share my property with local tourists who come to visit the Horseshoe Sanctuary, as well as there's a military complex in Dover, and I've hosted a number of families that come visit their families that are stationed at Dover Air Force Base. This is a unique opportunity for people to come and enjoy the horseshoe crabs as well as reunite with nature. I'm committed to ensuring that the proposed changes align with the community standards and environmental preservation efforts. I'd be able to answer any questions that you may have.
Thank you. Any questions? Board.
I have some questions.
Sure.
So when you purchased this property,
Yes.
did you realize that that was not permitted? I mean, because, you know, this particular community has its own regulations as well as the county regulations. So that's my first. Did you look into that? Was there anything at any time that you read that said you would be permitted to do this?
So before I purchased the property, I called the Levy County phone number to ask about the short-term rentals. And as a matter of fact, I called even a month ago when, before submitting the application, and even a month ago when you call the Levy County phone number, majority of the people there, they answer the phone, have no idea of the procedures of applying and getting a permit to do short-term rentals. So I have recorded calls if you'd like.
So this meeting here that you're attending, or application that you are filing, is your first attempt at being approved, asking for approval to have this. Nobody in Levy Court said that you could have this, that it didn't meet the qualifications, and you did not receive a rental license or a permit from the county to do any of this. True?
Correct. Okay. This is my first time before the board.
So that's my first question. Mm-hmm. And how much of the year will you be in Connecticut, and this will be like an absentee landlord, if it were approved, would be an absentee landlord rental situation?
So this would not be an absentee landlord situation. Every single one of my neighbors have my cell phone, so I am available. My schedule is very flexible, and I try to be here. Well, we've owned it for 3 years, and for the 3 years that we've owned it, we've been here at least 3 to 4 days a month at the property year-round. Plus I have cameras on the property, so if there's any issues, I'm only 5 hours away. And that's with traffic.
But on a daily basis, it's not like you're renting an apartment and you're somewhat an absentee landlord. You're not living there constantly monitoring what a tenant, if you were allowed to have a tenant, what the tenants would be doing.
I could see the camera, the surrounding cameras. As a matter of fact, my community can probably verify this, but there were a number of robberies on the public. If you look at the property right here, can you go back a slide? Oh, the public parking. If you go back to public parking, right here, this area right here, there was a number of robberies, and because of my cameras that are facing that way, a couple of robbers have been caught and going through vehicles. I care about my community.
The next question is, we have received several letters from neighbors.
I am aware. All my neighbors are here to support me.
Asking that you not be permitted to do this, because this community has pretty much been the same. It's a little different, and it's been pretty much the same for like forever. So I
agree with you 100% that the community has sent in letters. However, the community is changing. In the past year, there has been a number of sales that have already happened with new people moving into the community, and there's 2 other Airbnbs in this community, also absentee owners or absentee landlords.
So this is to the planners. Do we have permits for Airbnbs? Have we ever? I know we had an application at one point which was denied some time ago. I can't even remember, but do we have any licenses and permits for people to rent Airbnbs and all that stuff there?
We do have them throughout the county. There has been approvals. Anyone would have to follow the same exact restrictions that this gentleman is having to follow. It's the same rules for everyone across the county. There is no different rules based on zoning.
So the only thing that would restrict him from applying to do that would be some type of a community deed restriction or rules and regulations, because we all know that's kind of that area.
He would have to meet all of our conditions, and then if there's deed restrictions, he would have to meet those as well. So if there is other ones in this area, I'm not aware. That doesn't mean that they do or don't have approval, but they would also have to meet the same conditions. This is here before you because there was complaints and there was code enforcement action taken on it, and the gentleman had come in for the variance to be able to still happen.
Okay, thank you.
A question for the staff. The language regarding the short-term rental, when was that adopted?
This new short-term rental was adopted approximately April of 2023. That's when we had the conditions put into the code.
I've owned the property since February 22, and I've done Airbnb since.
Where is your home residence?
My residence is in Suffield, Connecticut.
Thank you.
So when you purchased the house in 22, this was not permitted, because you just said you purchased it in 22, and we just had testimony that the change was adopted in 23.
The change was adopted in 2023, a year later, which at that point I was already doing Airbnb for a year at this property.
No.
There was no rules.
He bought the.
I called to verify before I purchased the property. As a matter of fact, I called a month ago the levy court system, and your operators still don't have any answers.
Thank you.
I have a question for staff. Are properties that were operating prior to this rule considered grandfathered in?
No, so they would have had to go through a different process. So prior to us having this existing code, we would have put them under a bed and breakfast that required a conditional use process. So there was a process for them before. To my knowledge, we didn't have any short-term rentals that had approval that went through that process. I don't know, there may have been, but to my knowledge, no one had went through that process. So if they were before April of 2023 and they wanted to do a short-term rental, they had to do a conditional use process. Now we have changed the zoning code to allow for short-term rentals specifically, but they have to meet the following conditions, one of them being it either has to be owner-occupied or it has to be 5 acres or more.
And just for the record, neither of those conditions are met in that testimony. Is that for portions of, I mean, like, of the year, it's not owner occupied.
Right, so he or the owners would have to be there when the rentals are there.
Thank you.
Can you just touch base on so we did receive a lot of letters. I mean,
19 to be exact.
Yes. And a lot of them were like disturbing the area. Can you just touch base on if you have any knowledge on that, or how would you rectify that issue?
Sure. So basically, if you read every letter, the beginning is pretty much the same, and all the letters are pretty much the same within a few different wordings, which is okay. I'm okay with loving my neighbor. So my neighbors, the complaints that they've had was that they want this to be a private community. Well, this cannot be a private community because there is a public. Right. If you look on the screen, this is public parking, and this is right here. This is public entrance to a public beach. So, for this to be a private community, the public has to be exited out. So the concerns are that one of the concerns was that I had 6 vehicles on my property at one time. Well, last weekend. There was a whale sighting off of the coast, and there was a line of cars. I have a picture if you'd like to see it on my phone. I don't know if there's a way to broadcast this. There is a line. Is there a way to broadcast this? Can I walk it to you? So back to my testimony, the things that you guys want to hear on the microphone. So the first picture I showed you was a line of cars, as far as you could see, of people coming to look at the whale whale sighting that was outside the beach. And the second picture that I showed you was people gathering and waiting for their turn to get to the beach in order to see this whale sighting.
Sir,
there's no way for this.
Did you take that picture? Did you take those pictures you showed us?
Yes, I took it off of my cameras. I took it off my cameras, my video cameras that are on the house, the surveillance cameras on the house.
Okay, thank you.
Yes. Any other questions?
No, I mean, don't you think that's more of like a special circumstances versus a recurring situation?
So since I've been in 20, since I bought the house, there's been more and more people coming to the beach. Now that the restrictions have been lifted, the COVID restrictions have been lifted, and summertime, it gets very busy. In about a month, it's going to get very busy for people wanting to come to look at the horseshoe crabs. Whole busloads come, mostly Asian people. There was one time, there was 4 big tourist buses taking turns, dropping people off, and the beach was full of people, not because of me, but because of horseshoe crabs, and this being recently turned into a public beach. Any other questions?
Any other questions? Nope, we're good. Thank you.
I'll ask. I mean, have there been occasions when, through the use of your video cameras or through communications with neighbors, that you've ever had to intervene to restrict or?
So, yes, there was one situation 2 years ago when there was a family staying, and a young girl, she was going to the beach through the dunes, and one of the neighbors called me, and I.
Thank you.
Absolutely. Any other questions?
Nope, I think we're good. Thank you.
Thank you. Thank you for your time.
Thank you. Is there anyone else that would like to speak in favor of this application? Okay. If you want to come forward, state your name and address and allow our attorney to swear you in.